We're starting this deep dive today with a story about a law student, Swapnil Tripathi. Back in 2017, he tried to get into a really important Supreme Court hearing.
And he was just turned away at the door.
Exactly. The courtroom was completely packed. And that simple act, being physically barred from seeing justice happen, it raises this huge constitutional question.
A massive one.
Does the public have a fundamental right to witness what goes on, or can the highest court in the land basically function behind closed doors? So today we're unpacking the Swapnil Tripathi v. Supreme Court of India judgment from 2018.
And it fundamentally redefined what open justice even means in our digital age.
So the people who brought this case, Swapnil Tripathi and Senior Advocate Indira Jaising, they weren't just asking for a favor.
No, not at all. They were demanding a constitutional right, the right to know, arguing that cases of national importance have to be broadcast.
So what was the old rule? What were they pushing against?
Well, the fascinating part is this very old legal tradition, the open court principle. It's rooted in Article 145 of the Constitution and Section 327 of the Criminal Procedure Code.
Okay.
And for decades, that just meant physical access, a literal open door to the courtroom. The court had to make this huge interpretive leap.
Right. Does this old idea tied to a physical room suddenly expand to include, virtual access?
Exactly. And the court didn't just look at tradition. They linked this demand for live streaming directly to the fundamental rights of every citizen.
Which makes sense. If you can't see the justice system, how do you really have access to it?
Precisely. The ruling connected it to the right to know under Article 19.1, that's free speech, and also the right to access justice under Article 21. It was a pivotal move.
So how did the court justify this shift? This is where it gets really interesting. They ruled that transparency isn't just a good idea, it's essential for democracy.
It is. And Justice D.Y. Chandrachud put it so well. He quoted Jeremy Bentham saying, "Publicity is the very soul of justice."
The whole sunlight is the best disinfectant idea.
That's the one. It's about accountability. Knowing that the public is watching, it keeps the process honest. It reinforces faith in the system itself.
And technology was the key. The court basically said, look, technology lets us overcome the physical limits that stopped people like Swapnil Tripathi. It brings the court to you.
But there was a lot of caution.
I can imagine. The risk of turning a serious court proceeding into some kind of spectacle.
Absolutely. Even the Attorney General, who supported it in principle, urged extreme caution, especially around privacy and dignity.
So the court had to find a balance.
A critical one. They decided transparency would be the norm, but they needed clear boundaries. They even started with a pilot project and a slight time delay.
Okay, so what are those boundaries? What are the hard exceptions?
They're very specific. No live streaming for matrimonial disputes or cases involving sexual assault, especially under the POCSO Act for minors, and nothing involving national security.
So really sensitive, private matters are protected.
Yes. The goal was to make sure transparency didn't end up causing more trauma or compromising someone's dignity.
So let's bring this to today. What does this actually mean for you, the listener? Well, you can now pull up YouTube and watch major constitutional hearings.
Like the Article 370 arguments or the same-sex marriage debates. It's incredible access.
It is. And it's a huge tool for accountability. You can fight misinformation by just watching the arguments yourself instead of relying on someone else's summary.
And for the legal pros out there, the takeaway is just as crucial. Open justice is the new default.
Meaning?
Meaning you have to be vigilant. For clients in sensitive cases like family law, you must actively ask for an in-camera or private trial. You have to cite these very guidelines. If you don't ask, the default is now open and on camera.
So in the end, the Swapnil Tripathi judgment really proved that the law has to evolve with technology to keep our democracy healthy, that sunlight really is the best disinfectant.
And it leaves you with a question to think about. Given how powerful this virtual access is, what's the next technological step for our judiciary? How can we improve access even more, say, for the visually or hearing impaired, without ever sacrificing the dignity and privacy of the people involved?